Happy Friday, everyone. My name is Cathy Tracey, and I am here with my colleague, Matt O'Rourke, to talk through some of the common mistakes that we have been seeing employers make under the FFCRA. So I am hoping, and I've made the promise to the team here who's putting this out, that we're going to try and make this webinar a little more brief than some of our other ones. So let's see how we do. As usual, we will start out with some quick headlines. In the world of COVID-19, first is Southwest Michigan saw the lowest number of positive tests for COVID-19 to date since we saw the spike, so that's good news. In other good news, Governor Whitmer is reopening auto dealerships and retail businesses by appointment. She's authorized non-essential medical, dental, and veterinary services and is allowing small gatherings throughout the state. The Michigan Court of Claims ruled yesterday that Governor Whitmer did exceed her authority under the Emergency Management Act, but does have the authority to extend the state of emergency under the Emergency Powers of Governor Act of 1945. So that came from the Michigan Court of Claims. The U.S. Senate has also left without passing the Payment Protection Program fix, which would extend the window for businesses to spend PPP money from 8 weeks to 16 weeks. So with that, I'm going to turn it over to Matt O'Rourke to talk about the first mistake that we're seeing under the FFCRA.
Well, good morning, everybody. And before we get into the mistakes, I just want to give a bit of a warning here. It's about 8 o'clock here in Grand Rapids, and 8 o'clock in the O'Rourke household is breakfast time for my 14-month-old son. And he likes to scream and shriek during breakfast time. So if you hear him in the background, I apologize in advance, but please also know that nothing is wrong. That is normal for us. Such is the world we live in today of working from home. But that's not why you're here. You are here for common mistakes that we see with the FFCRA. And the first mistake, we'll get right into it. So we sometimes hear from clients that the normal FMLA eligibility requirements apply to the extended or the emergency FMLA, right? So employees are only eligible if they've worked for 1,250 hours during the year and they've worked for our company for a year. Unfortunately, that is not correct, as Dwight Schrute would tell you here. The FFCRA has different eligibility requirements, both from the standard or normal FMLA and different eligibility requirements for extended FMLA and emergency sick leave. For extended FMLA, an employee is eligible if he or she has been employed for at least 30 calendar days. Emergency sick leave is even shorter. It's just if an individual is an employee, he or she is eligible. So there's really no waiting period for that. Hopefully by now we understand some of these eligibility issues, although I think we're going to start seeing more requests for FFCRA benefits as more and more employers start to return to work. So these are important things to keep in mind. On to number 2.
So this turns it over to me. Matt and I are going to kind of go back and forth a little bit. So the second mistake is, this comment: no, you can't take leave under the FFCRA because your grandchild's school is closed. That leave is only available for people who have a son or daughter. Matt, can you advance that slide? And advance it again. So an employee is entitled to take FFCRA when they need time to take care of a, quote, son or daughter whose school has closed, which means all schools in Michigan, or whose childcare is unavailable. So you may be thinking, well, what's wrong with telling a grandparent that she can't take FFCRA leave since a grandchild is clearly not a son or a daughter? And in some cases, that might be right. However, the Department of Labor, in their regulations, define a son or daughter as a, quote, biological child, adopted or foster child, a stepchild, a legal ward, or a child of a person standing in local parentis, who is under 18 years of age or 18 years of age or older and incapable of self-care because of a mental or physical disability. If you could advance the slide, Matt. So the key word in that definition is in loco parentis. So to be in loco parentis, it basically means that person is standing in the place of the parent. So sometimes, depending on the relationship between a grandparent and a grandchild, they stand in loco parentis to the grandchild and therefore would be entitled to leave under the FFCRA. So that obviously begs the question, what on earth is in loco parentis? Basically, it means that it's a person who has day-to-day responsibilities to care for or financially support the child. So, and if a court was going to evaluate whether a person is standing in loco parentis, they would look at things like the child's age, the extent to which the child is dependent upon that person. Is the person financially supporting the child? And, you know, are they doing other things that are typical of parenthood for that child? And if all of that is true, which sometimes occurs if you have a grandparent who has a grandchild living with them, then that person should be covered by FFCRA. Now, all of the other rules apply, of course. You know, as you all probably know, under FFCRA, the person standing in loco parentis or the person who's taking leave to care for a child is supposed to be the only person available to do so. So I think the key here is just making sure that you don't turn these requests down immediately, and that you ask a few more questions and give it some thought before you simply say, no, you're not covered. And with that, I'll turn it over to Matt.
All right, mistake number 3, documentation. So we've heard that some employers are not documenting when employees are taking emergency paid sick leave or extended FMLA leave because, let's be honest, you have so many other things on your plate that documenting some of these things in the moment isn't necessarily a priority. And so, you know, if an employee tells you that he or she has COVID-19, we're just going to pay her while she's out sick and then figure out the tax credits later. Well, as you might imagine, that's the wrong answer. When it comes to documentation, the IRS has some pretty specific requirements, and a lot of this has to happen in the moment if we're going to be in a position that we can claim the tax credits later on down the road. So according to the IRS, anybody who requests leave under the FFCRA needs to provide a written request with the employee's name, the date or the dates for which the employee is requesting the leave, a statement of the reason why the employee is requesting the leave. So if we look at the reasons in the Emergency Paid Sick Leave Act, the 1 through 5 reasons that we are all familiar with by now, we need to know which of those reasons is the reason for the employee's leave. And then a statement that the employee is unable to work, including telework, because of the reason for the leave. It's pretty simple. We normally get this information whenever an employee is requesting leave, so this seems pretty straightforward. But there's more. So the additional information we need after that depends on the reason for the leave. So if we look at the first 2 reasons, an employee who is on leave because of a quarantine or isolation order, or who is self-quarantining based on advice, then the request should include the name of the government entity or the healthcare professional who is advising the employee to self-quarantine. So I want to talk about number 1 there for just a moment, because in Michigan, we have Executive Order 2020-36. That was the order that said employees are allowed to stay home from work if they either interact or have close contact with somebody who has COVID-19 or the principal symptoms of COVID-19. That executive order also said, however, that employers may not retaliate or discipline employees who do not provide medical documentation to support their need for the leave. So we have we're in a bit of a tough situation here because the IRS is telling us that we need some of this information. We need information about the government entity or the healthcare professional, but Michigan is telling us that we can't. We can require employees to provide it to us, but we can't do anything to them if they don't provide us some of that medical documentation. And so this is why it is especially important to get this information from employees up front. We need to know exactly why they are needing the leave. If it's because under the executive order they qualify for leave, then let's make sure we document that and make sure we document the exact executive order number so that we have it in our records. And to the extent that we can get information from the employee about who they interacted with, when the interaction was, what the interaction was, the more information we have, the easier it's going to be to work with the IRS on the back end of things. I know when I say work with the IRS, that sends shivers up my spine because that doesn't sound like a fun experience for me or for anybody else out there. So as I'm sure you can imagine, the more we have in place going into those interactions, the better off we'll be. But I'm not here to trash the IRS, so let's move on then. If a person is subject to quarantine or advised to self-quarantine when they're helping somebody else, so reason number 4, caring for somebody else, we need to know the name of the person who our employee is caring for and also their relation to the employee. Number 5, if leave is based on school closing or child care provider unavailability. The IRS tells us we need the name and the age of the children, the name of the school or the place of care that is closed or unavailable, and then a couple of representations from employees. One, that no other person will provide care for the child during the period of leave, because obviously if there is somebody else providing care for the child, then our employee doesn't need leave or shouldn't need leave. And then the second is if the child is older than 14, it's a good thing I can talk this morning, and needs care during daylight hours, the IRS wants us to get a statement from the employee that there is some sort of special circumstances that exist that require the employee to provide care. And obviously that statement should include what those circumstances are. Now, this all seems somewhat daunting when we put it on some PowerPoint slides here, but if you haven't already worked with us in this regard, I can tell you that we have forms that we've developed that will cover all of these requirements. So if you work with your favorite employment attorney, even if he or she is not named Cathy, Tracey, or Matt O'Rourke, we'll forgive you, but we can help you put these forms in place and make sure that you have everything you need to document the need for leave. Oh, but wait, there's more. You thought I was done. When it comes to documentation, we also have to retain the records when we get all this information. And then we need to retain a couple other things as well. And so this is where we're getting into the scary part of the IRS, where these are big words and big forms. And I think, if we don't work with these on a regular basis, it couldn't hurt to reach out to your attorney to make sure that we have everything in place. But we need documentation to show how the employee determines how the employer determined the amount of qualified sick and family leave wages. So the calculations that we do to decide how much we're paying the employee. Documentation to show how we determined the amount of qualified health care plan expenses that the employer allocated to wages. Copies of forms that we've submitted to the IRS, both the advance of employer credits due to COVID-19 form and the quarterly federal tax return form. So again, a lot of moving pieces. We want to make sure we have everything in place because these tax credits are a valuable benefit to us. But as you can see, the IRS in their typical fashion is not going to make this easy. And so again, we are here to help. And my last point on this, before we can move on from documentation, is that the IRS tells us we need to keep records for all of this for 4 years from the date that the tax becomes due or is paid, whichever is later. So make sure we hang on to this just in case there's some sort of audit or questions later on down the road. And with that, let's move on to number 4. Cathy?
Well, you thought you were off the hook now that we're not talking about documentation anymore, but now we're going to talk about quarantines. So this one is, my employees are quarantined because the governor's stay-home order still applies to my company, and there's no in-person work. I'm going to give everybody FFCRA leave until I'm back in business. Can you advance that slide, Matt? And as you expect, that's not quite right. The Department of Labor does very broadly define a quarantine or isolation order to include any state or local stay-at-home order. So Governor Whitner's stay-home order is clearly a quarantine or isolation order under the FFCRA. However, that specific order will rarely, if ever, trigger FFCRA coverage because in order to do so, it must be the order that prevents the employee from coming to work. If the order prevents the employer from opening or limits the employer's operations such that the employee services are not needed, it's the order's impact on the employer, not the employee, that's causing the employee not to work. And that's not covered by the FFCRA. So, why does that matter? It goes back to what Matt was just discussing. It matters because if you are giving people FFCRA leave for a non-qualifying reason, you're not going to be entitled to the tax credits for that. One thing you should watch out for, and I think we'll all have to continue to watch out for as we move forward with reopening, is that executive orders that prevent employees from working are going to trigger the FFCRA. So in the state of Michigan right now, that would be Executive Order 36, which Matt referenced a little earlier. That's the executive order that prohibits employers from disciplining or discharging employees who need to quarantine because they have symptoms or a diagnosis of COVID-19 or because they have had close contact with somebody who has symptoms or a diagnosis of COVID-19, subject to certain industry exceptions. And the reason is because not only does that order prohibit discipline or discharge, it also tells employees that they should be self-quarantining if they had symptoms or diagnosis of COVID-19 or been in close contact with somebody who has symptoms or a diagnosis of COVID-19. So because that one would prohibit an employee from coming to work, even if the employer would allow it, that type of order is going to trigger FFCRA coverage. And with that, I will turn it back over to Matt.
All right, if I can get the slide to move here, we'll move on to number 5. There we go. So mistake number 5. Employee at the beginning when the FFCRA went into effect on April 1st requested extended FMLA leave because their kid's school was closed. So we gave them 12 weeks of leave that they were entitled to and said we'd see them in July. This could be a problem. And the problem is, according to the Department of Labor, paid sick leave and extended FMLA are not available for reason number 5, that reason being that school is closed or daycare is closed, if the school or child care provider is closed for summer vacation or any other reason that is not related to COVID-19. So if the school or daycare would have otherwise been closed at that time, that's not something that falls under the FFCRA and entitles somebody to either leave or paid leave. So if we think about this, here in West Michigan, I just listed some of the bigger school districts there and when they were scheduled to close this year. So Grand Rapids Public Schools were scheduled to close on June 3rd. That was their last day of school. So if we have an employee whose child attends Grand Rapids Public Schools and that employee has been out on extended FMLA leave because the school was closed and the employee needed to care for the child, that leave will be expiring on June 3rd. Now, there may be other reasons after that why the employee would need leave, but we're going to have to dig into it a little bit and ask the employee then to submit a request for leave based on new circumstances, whether it's Typically, the child would attend a summer camp starting on June 4th, and the summer camp is closed. Well, the DOL said that summer camps would qualify as a type of child care provider, and if that's closed because of COVID-19, then that would entitle the employee to the same benefits as if it were because of the school being closed. But again, we can't just automatically say, well, you started on your leave on April 1st, and then we're going to count 12 weeks from there, and then you can come back on whatever the date would be in July or the end of June, if the original reason for the leave was solely because the child's school was closed. So that's something to be aware of and something we'll need to look into and see the last day of school or the scheduled last day of school if the employee is out because of school closure.
Mistake number 6 is forgetting about other employment laws outside of COVID. This one is, I had an employee request leave because he is extremely anxious and depressed about everything going on with COVID-19, but I know that is not a reason for leave under the FFCRA, so I told him that he really needs to come into work. It is true that employees are not entitled to take leave under FFCRA simply because they are anxious about COVID-19. However, one thing that we've noticed as a section is that a lot of employers have become so concerned by COVID-19 and all of the new laws and guidance that many of us are forgetting to consider some of our good old employment laws that we spent a lot of time dealing with and thinking about before COVID-19. For instance, the Family Medical Leave Act. So in the example above, the employee mentioned that he was anxious and depressed, which could very well qualify as a serious health condition under the FMLA, and to the extent the employee is eligible for FMLA leave, that may be a basis on which he would be allowed to take leave of absence. Similarly, anxiety and depression may be a disability under the Americans with Disabilities Act. So we would need to consider whether that employee does have a qualifying disability, whether leave would be a reasonable accommodation under the Americans with Disabilities Act. There's an argument, I suppose, that a leave under the ADA would not be reasonable because it's indefinite, but I think that's something that we would need to think about and certainly consider in connection with the medical certification and information that we have about the employee at that time. So the communication here is just, while all of these new laws are important and we need to understand them, let's not forget about all of the other issues that we all know and love.
All right. Mistake number 7, amount of sick pay. So we've heard an employee only needed 40 hours of emergency sick pay, but we let him take an extra 3 days because he's entitled to 80 hours total. No big deal, right? Sick leave. Well, it is kind of a big deal because, again, when we get and look at tax credits and we look at emergency sick leave eligibility, employees are only entitled to take the amount of emergency paid sick leave for which they qualify. And if an employee only qualifies for a certain number of days, he or she can only take those days. So employees are capped at 80 hours total of emergency paid sick leave. Let's take, for example, an employee who uses 64 hours in April for reason number 3. And then in May, the employee requests time off because he or she interacted with somebody who has COVID-19, and that would likely qualify for emergency paid sick leave under reason number 1, because now they have to quarantine because of Executive Order 36 here in Michigan. Well, because the employee took 64 hours in April, he or she only has 16 hours left for this part of the leave. So 16 hours would be paid, the remaining would be unpaid. But when we kind of get back to the original premise of the question or the mistake, when we're talking about allowing employees to take extra leave, we can, just like we would in any other situation, allow employees to take as much leave as either they are legally entitled to or as we want to give them, at least the greater of that amount. But when it comes to calculating how much of that leave comes out of their emergency paid sick leave bank, we need to make sure that it's only the amounts for which the employee was actually eligible for that leave. And when it comes to calculating tax credits, we need to make sure that we are only claiming tax credits for the amount of leave for which the employee was eligible. And so while it's no problem from an employee relations perspective, if we want to be very generous and give employees a little bit of extra leave, when it comes to calculating their eligibility and their sick bank, at least their emergency paid sick leave bank, we need to make sure that we're only using the amounts that they were actually eligible for when we subtract from that bank. The same goes for tax credits. So I've heard this before where employers want to be generous and they want to pay their employees 100% of their wages when the employees are on the extended FMLA leave, even though the law only requires employers to pay 2/3 of those wages for the last 10 weeks of it. That's fine, and there's certainly no problem with it, but when it comes to collecting the tax credits, employers are only eligible for the tax credit in the amount of the 2/3 for which the employee was eligible. They can't claim the extra tax credit for that extra third just because they were generous. And so we just need to make sure that any benefits that we offer above or beyond the requirements of the law, that we track exactly what we're doing and that we make sure that we keep good tabs of both the eligibility or the amount of time that employees have left and then the amount of the corresponding tax credits that we claim afterwards. And with that, as we promised, we would make this quick, and we have gone through our 7 common mistakes that we've seen with the FFCRA. Before I let you go, I just want to mention one thing. As you have hopefully heard by now, Nora Johnson has put together a resource center that provides a number of good, I hate to use the word resource after I just said it in the title, but a number of good resources for employers who are either returning to work or preparing to return to work or working with employees now through all the different executive orders and requirements and laws that have changed and affected our lives. And so the Resource Center was just updated yesterday. It is updated regularly. We just added 2 new training videos yesterday, including one for supervisors and one for all employees. And so if you have not yet subscribed to the Resource Center, the information is there on the website. I strongly encourage you to do so, although both Cathy and I and all the other folks here at Nora Johnson are happy to work with you and answer your questions and do whatever we can to make sure we put you in a good place moving forward. So with that, there is our contact information and our smiling faces. I want to thank you for tuning in this morning, and I hope that you have some time this weekend to relax and unwind and enjoy the long holiday weekend. Thank you very much, and have a good one.
Well, hey, thank you, Trip, and thank you, everyone, for joining us today.